Thanks to everyone for tuning in today to our Labor and Employment Group's first podcast. And I'm looking forward to having a chat with my partner, Chad Sullivan, who's in Fredericton, New Brunswick office, and Kathleen Nash, an associate in our Fredericton office as well, to speak about these federal workplace harassment and violence regulations and what employers in Canada need to know. So welcome, Chad and Kathleen. Thank you so much. I think today what I want to focus on is some of the difficult issues that employers will have to deal with when dealing with complaints. And I guess what I want to sort of focus on at the beginning of the discussion is the more gray areas of harassment. And I look at the Canada Labour Code definition, and I'm just going to read it here. It says, any action, conduct, or comment, including of a sexual nature that can reasonably be expected to cause offense, humiliation, or other physical or psychological injury or illness to an employee, including any prescribed action, conduct, or comment. And obviously that's very broad. And then when you go on the Government of Canada has helpfully provided some guidelines, and they even have a sample harassment and violence prevention policy for this mythical Delta company. And when I look at their policy, that sample policy, it includes such things as spreading, in the definition of harassment, it includes such things as spreading rumors or gossip about an individual or group, socially excluding or isolating someone, misusing authority, including restricting information. And then the Delta Company policy also says that consensual workplace banter and interactions is not harassment, and reasonable management action is not harassment. And I guess sometimes, and maybe this is too simplistic, but I think it's accurate in many respects. The workplace is sort of like high school in some respects, and I'm having trouble thinking of too many workplaces. I can't think of too many workplaces that there's not some rumor and gossip, and that every workplace has cliques. So I guess, Kathleen and Chad, what I'm trying to figure out is, am I being too alarmist in thinking that this broad definition is going to cause a lot of issues for employers?
No, I think that is a legitimate issue, Rick. And so these federal regulations came into effect January 2021, and they're 24 pages of very detailed processes that an employer must follow upon getting a complaint. And there's a very broad definition of what constitutes harassment and violence. If you're a federally regulated employee, now when you get a complaint that falls under this very broad umbrella of what constitutes harassment and violence, you now have this very detailed, lengthy regulation that you have to follow, right? So I guess the point is, given your broad definition that you just read, no matter how trivial a complaint is, if it falls under that broad umbrella, an employer, a federally regulated employer, is going to have to follow the process. And that's exacerbated by the fact that, and I'm sure we'll get into this, and I don't want to get ahead of ourselves, but under this very specific detailed process, under the federal regulations, it's largely driven by the victim, and there's no real screening process. This is a gray area, and I'm sure we'll get into it. But arguably, there's not a whole lot of discretion by the employer initially to weed out sort of trivial claims.
Right. And I guess I refer to this sample harassment and violence prevention policy of the Delta company, and I presumably. There would be an argument, and I stress the word argument, that in fact this is not necessarily the be-all and end-all of the definition of harassment. This is just the Government of Canada's perspective on what harassment may mean. Am I overstating that, Kathleen, or is that a potential argument that could be made?
I think the point of having such a broad definition is that you can't have a specific definition of what is going to constitute harassment, because there's going to be so many different circumstances where someone might perceive something to be harassment, and trying to find a specific definition and provide examples is going to be impossible.
Right. And we all remember, the first day of law school. We learned about this reasonable person, and I think pretty much law school in the last 20 years of me practicing law has been trying to figure out what reasonable means. But when I look at the Canada Labor Code definition, it does say reasonably be expected to cause offense. So I suspect that an employee who says, "Well, gee, I wasn't invited to lunch, by others one day," and I'm not trying to be trite, but couldn't probably legitimately say that they've been socially excluded, because presumably that would not satisfy the reasonably be expected to cause offense. Is that am I close to what we hope would be a reasonable interpretation of that definition?
I think in the situation that you presented, maybe there's some gray area for the employer to actually screen out and say, this doesn't fall under the definition. But the way that the process works is you have to deal with complaints. And so when you get a complaint, there's certain steps that you have to take, including the first step is the employer screens it to make sure that the complaint, which can be verbally or in writing, to make sure that the principal party or the victim is identified. And if they're not, then they can dismiss it. When it gets into whether or not the specific conduct at issue meets the threshold of violence and harassment, I think the way, and we're talking about this without having any case law on this issue yet, but I think that can only be done in concert with the victim. So there's a specific provision under the new regulations that say your first step is to notify the victim and meet with the victim. You have to notify them within 5 days, and there's all sorts of timelines. But your first step is you notify them, and you, if you can reach a negotiated resolution, which includes the victim and the employer agreeing that the conduct at issue does not constitute harassment and violence, then everything ends there. But you need the victim's approval at that stage. So it's a gray area for me in terms of how much latitude is granted to employers under this new legislation for screening complaints that it deems doesn't meet the threshold. And as you've pointed out, that's exacerbated by this this draft policy, right? That sets out these potentially very trivial matters that an employee could later rely upon to say, look, it fell under this. It clearly fell under this draft policy that was issued by the federal government. Something should have been done about it.
And I think we all need to understand as well, and presumably Kathleen, you'd agree that that when a notice of occurrence, or I'm using the language used in the Canada Labor or the regulations, but let's just call it a complaint. When a complaint is made, I think, as labor and employment lawyers who have to deal with this and helping HR people deal with this on the ground, so to speak, inevitably, these kinds of complaints cause discord in the workplace, and so it's something that that has to be dealt with, and workplaces come in all shapes and sizes, small and big, and particularly small workplaces, and there are some small federally regulated workplaces where these complaints inevitably, will make its way, because whether we like it or not, people talk. Am I right in saying that, or is there some magical process that we can make sure that these complaints don't cause any discord in the workplace?
No, I think you're right. And part of this, like Chad pointed out, is because this is kind of a gray area. The person who receives the complaint or the notice of occurrence doesn't have as much of a discretion to talk through the complaint with that person. They do have to go forward with it unless, like Chad said, the principal party, so the victim, can't be identified. So like if a witness came forward and brought the complaint, but didn't want to identify the person who was involved, then the employer has some kind of discretion. But otherwise, these do have to go forward. And in a small workplace, there's no way for it to not really be known that it's going forward.
And I guess the other part of these regulations I found curious, so to speak, was the parts of the regulation that suggest that both the principal party, which I'll call the complainant, and the responding party, the person that's alleged to have engaged in harassment and violence, may be represented during the resolution process. And when I looked at the I call it the interpretation policy, it says the following individuals may represent the complainant and respondent. A union representative, which I can understand. A colleague, presumably a colleague means a fellow employee. A spouse, a partner, a family member, or a friend. I can't help but think that in many circumstances, practically having, and I'll say, for example, if there was a serious sexual harassment complaint made, I can't think of a worse scenario than the spouse of the complainant and the spouse of the respondent somehow being representatives and being sort of in a process, engaged in a process where they're trying to get a resolution to the issue. Am I out to lunch on this, or is that an issue?
No, I think that's a very real issue. So this issue was identified a few years ago when the legislation was in draft form. So this piqued the interest of many lawyers when this first came out in draft form, saying that both the respondent and the victim can be represented during the process. And so everybody at that time just assumed that meant a lawyer. And so, the ability to have a lawyer during all the conciliation, the negotiated resolution, and the investigation process, everybody thought, well, that's not going to be helpful. This is supposed to be an expedited process, and lawyers are just going to complicate things, right? And by the way, employees, I think it's pretty clear through the regulations guideline that they can still have a lawyer represent them. It can be anybody. But now what's come out through this draft policy and the guideline is, all these different individuals that can represent the person. So instead of having, two emotionally charged individuals, the victim and the respondent, you might have the spouses there as well, which I can't imagine would be a good thing in most cases. Luckily, the guideline issued by the federal government does speak to this and says that they can help you during for administrative reasons or during the updates that you get, and they can speak on your behalf with respect to scheduling meetings, receiving updates, those sort of administrative things. But you're still required to answer questions during the investigation. So the guidelines, I think, are really good for employers to rely on at this point to really limit the role that the support person plays.
So let's move on to the part of the regulations that talk about the resolution of an occurrence, and I call it a complaint. So it talks about how that there has to be you have to make every reasonable effort to resolve an occurrence, and sort of what does reasonable effort mean, and if it's not well defined, what would we say to our clients about the extent of the effort they should make to resolve the complaint? Any thoughts on that, Kathleen?
I think, like we talked about with the definition of harassment, reasonably, people have been trying to define reasonably for as long as the law has existed. So I think for making every reasonable effort, employers would be very well served to try and make every effort possible to resolve the occurrence, and then there can't be a question that they made every reasonable effort. They don't have to go, I wouldn't say take every step possible, but making a reasonable effort does mean that there's going to have to be steps taken and effort to try and resolve it at that point.
So, I also looked at the regulations, and I saw that that a witness may provide notice of an occurrence anonymously. And I guess recognizing I don't want to be too cynical, but I could see that maybe some anonymous complaints could be filed or presented with less than positive intentions. Again, am I too alarmist on that, or is that an issue that could arise under these regulations, particularly because it's written down? Any thoughts on that?
Yeah, no, I think a lot of employers, and as you said, a lot of employers have anonymous tip lines, which are good to have, but a lot of employers also have a policy that, look, if you're not willing to put this in writing, you know, we can't move forward. And rightly or wrongly, that, you know, a lot of employers have that, and there's some benefit to doing it. But under this new legislation, and federally regulated employers have to deal with verbal and written complaints, and they can be from witnesses who are anonymous. And so certainly you know that does pose a problem from probably our labor relations standpoint, that, you know, some damage is going to be done by these witnesses who aren't putting their name on a complaint. But I think the intention is to make sure that complaints are brought forward and people aren't, you know, scared of the repercussions from those. And so I think there is some benefit, especially for, you know, serious complaints where employees, you know, might be complaining about a higher up employee, to have that ability to submit an anonymous complaint. And I think a lot of the potential downside to it is hopefully protected by this process, in the sense that it's driven by the victim, right? So you get this complaint from an anonymous witness. Your first step is to contact the principal party. You also have to contact the witness just to let them know that you received it, but it's driven by the victim, right? So you meet with them, see if, and they can put a stop to it at any point. What an employer does, you know, depending on the severity of the situation, is a different question, but it's driven by the victim. So if you have an anonymous complaint, you meet with the victim. If they don't want it to go forward, it doesn't. If they agree that nothing happened, it doesn't go forward. If, you know, you can negotiate a resolution, it doesn't go forward. So I think the fact that it's driven by the victim and not the witness probably does away with a lot of that concern.
No, that makes sense. And I guess, Chad, I just want to be clear, and it may not be that clear. It says a witness, and I'm reading from the regulations, a witness may provide notice of an occurrence anonymously. So I'm understanding that means the employer may not know who actually the witness is. Kathleen, any thoughts on that?
I don't think so. In reading it, it does say a witness may provide the notice of occurrence. So, like you've both pointed out, the principal party does have to be known. And at the initial stage, if the employer can't determine who the principal party is, then the complaint doesn't go forward. So that might alleviate some concern with anonymous complaints just trying to cause issues. And if the principal party, being the actual victim, doesn't want to move forward with it, then it's not going to move forward. So even though anonymous complaints might cause some issues sometimes, I think that distinction there is going to help alleviate some of those issues.
So if we, I guess that leads in nicely to the situation that that employers often find themselves into, and it's whether you're federally or provincially regulated, is that a complainant makes a complaint, or under these regulations, a notice of occurrence, and for whatever reason, at some point, maybe and often prematurely, the complainant says, "Look, I want to stop. I stop this process. For whatever reason, I'm satisfied that I don't want this to proceed any further." So, does the fact that Section 18 say that they can end the resolution process at any point, does that mean employers should I'll say, follow the complainant's direction and not consider the matter any further? Or what should employers do in those sticky situations?
So first and foremost, there is something under regulations that they have to do. So under, I believe it's Section 6, it says in those situations where a complaint has been made, but the principal party withdraws it, the employer has to do a joint review with their workplace committee or health and safety representative of their workplace assessment, and review it and update it if necessary. So that's something that employers aren't going to want to miss. So that's step one. But more broadly, I think employers are well counseled, especially in serious cases, to follow up and deal with the situation. So as employer side counsel, we often see the situation where you have a terrible employee who's been at the organization a very long time, and all of a sudden, nobody can work with them anymore. And you ask the employer, well, what did you do? What kind of progressive discipline do you have on their file? And there's nothing, right? And so it becomes very hard to terminate that terrible employee when you haven't managed them, you haven't imposed progressive discipline, you haven't addressed issues as they've arisen. And it's not helpful when they've been there all those years. You're looking at a long notice period, and just cause is going to be difficult to make out because we don't have anything on file showing that we were trying to manage them all along. So I think employers would be well advised to follow up and not necessarily end it.
And one part of the regulations that I've always struggled with, and I don't think that there's a great answer, and hopefully there's some cases that provide some guidance on this issue, is the investigation and the investigator's report. And I guess I'm looking right at Section 32. When I say that, it says an investigator's report must not reveal directly or indirectly the identity of persons who are involved in an occurrence or the resolution process for an occurrence under these regulations. And then the question is, I'm just trying to figure out, what does the employer do with that report if, in fact, it doesn't necessarily identify the witnesses, because it says directly or indirectly. So I don't even think initials would work in that case, which we know investigators often will do. Does that cause a problem, or am I again being too alarmist and raising issues that really aren't there?
Yeah, so I think my view is, and again, we're speaking and having no clear guidance on this issue, but my view is, the reason why that section is worded the way it is, requiring an investigator not to identify anybody directly or indirectly, is because what is done with that report, at least under the legislation, is the employer has to meet with its policy committee to determine what recommendations it's going to implement. And so they have to jointly agree on what recommendations from the investigator are going to be implemented. And if they can't agree, the employer's decision rules the day. So I think employers can and should use that report to decide whether to implement discipline. including termination. And, that's practically speaking, that's what these reports ultimately lead up to. Now, the fact that it's not going to identify anybody directly or indirectly might present some evidentiary issues if and when you go to an adjudication or you go to trial. It just might, but I think there's a lot of ways that employers can get around that, including by calling the witnesses. Normally, employers, practically speaking, are going to know who the players are.
I could see employees possibly, and maybe Kathleen, if you could sort of opine on this, I could see employees saying to an employer, well, I recognize you have this report, and look, let's be honest, you can see the cross-examination by the Employees Council. You knew who these witnesses were referred to in this report, although it doesn't say, but you know this workplace pretty well. You knew, but you still made the decision to terminate. And did you interview those witnesses? And I guess, before you decided to terminate, so you could make your own independent assessment. And then I presumably, some employers may be, extremely reluctant to do that for, I'll say, the practical reason that, these probably being, interviewed about this incident, whatever it is. But, if it's violence or harassment, you can guarantee there's going to be some emotion associated with it. They don't want to do that. They don't want to put that employee through that again. And then they'll be challenged for, maybe not, making a decision to terminate, not on the basis of knowing all the facts, but relying upon this investigation report.
I think one thing that might alleviate some of those concerns is that an investigator, for the purposes of the regulation, has to meet certain conditions. So it can't just be anybody. The person has to have some experience investigating these types of things. So I think like an employee raising an issue that the investigation report just wasn't well done and the investigator really didn't ask all the relevant witnesses and didn't talk to them. I'm not sure if that's going to be as big of a concern. And I think the employer, because of that, could rely on the investigation report for discipline. And like Chad said, it might cause evidentiary issues in future processes, but there's been no case law on this. So,
well, I guess that's about it for today. I just want to thank both you, Chad, and Kathleen, for sharing your expertise on what I think we all agree that they're complicated regulations. There's no question they're important regulations, and they're regulations that address a very pressing issue, namely workplace violence and harassment. But there's no question that I think we all agree that that they do raise a lot of complicated practical, procedural, and legal questions that employers have to be mindful of when navigating each unique situation. And so I'd be remiss if I didn't point out that both Chad and Kathleen have written articles on these regulations, these summaries, and they're on the Stuart McKelvey website. So if you would like more information on this and other labor and employment issues throughout Atlantic Canada, you can visit our website at stuartmckelvey.com, and obviously you can contact any of our lawyers. And please don't forget to follow and subscribe to our series, Workplace Issues in Atlantic Canada, A Legal Perspective, and we look forward to seeing you next time.